All right, let's start our afternoon court calendar, and we'll do that by calling the case of the state versus Cameron REUTER, case 25 CF 2607. Appearances, please.
Kelly Zettel for the state of Wisconsin.
Cameron REUTER appears by attorney William Rakestraw. Mr. REUTER is not eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and enter pleas of not guilty to any misdemeanors.
All right, thank you. And I do want to confirm that he can hear us okay. Mr. REUTER, if you can hear us, would you please wave or give us a thumbs up? There it is. Thank you very much. I appreciate that. He does have an open case. I believe that case is assigned to Judge Schlipper in branch 3. So we'll get this case assigned to that same judge. Before I call on the lawyers, I understand there may be one or more victims present on Zoom who wanted to speak. I do see that Susie Effinger, Efinger, has her camera and audio activated. Ma'am, if there's anything you think I should know about bail or conditions of bail in the case, now is a good time.
Okay, good afternoon. Yeah, basically, as you probably saw by his record, he suffers from bipolar episodes, and unfortunately, if he were to drink alcohol, he'll have an episode, which is what we believe happened on Thursday night. So the bail conditions that are set, we are okay with. I'm just concerned right now that he's not been getting medication that he needs while he's in jail. He's been there since Thursday night and has only gotten one that really isn't for the bipolar. He needs the lithium. So I've reached out to his case manager, his psychiatrist, his therapist. We're all trying to get that taken care of for now. That's my main wish. We just really want to get him some help. And I know he's willing to get help.
Understood, and I appreciate that information.
Thank you.
And I do see that Brian Effinger is also logged in. Sir, if there's anything you wanted to add, you're welcome to activate the microphone and share that. All right, I'm not hearing or seeing anything. I'll make sure to come back to it though before any decisions get made here. I also think I misspoke. I think I described there as being one open misdemeanor case. In fact, it's 2 that are assigned to Judge Schlipper. State's position on bail?
Your Honor, the state is asking for $1,000 cash bond with conditions that the defendant have no contact with Kira H. Kira is spelled Kira. That he be banned from the 300 block of, I'm going to double check this address, I'm sorry. From the 300 block of Southing Grange, so that's spelled Southinng, second word, Grange, normal spelling.
Okay.
And I'm sorry, I think I have to go back to the previous note. I was checking the spelling of that. The state is also requesting condition that the defendant not consume or possess any alcohol, and that he sign up with and comply with pretrial services alcohol monitoring. As the court mentioned, the defendant does currently have 2 other open cases. They involve some of the same parties. The case here involves Act 3 offenses, a number of them. Also involves the defendant running from police. I think at this point in time, although I acknowledge that the defendant doesn't have any prior failures to appear in his open cases, we are at a point where some amount of cash is appropriate to ensure appearance. Additionally, I think the alcohol-related conditions are more than appropriate given what we've just heard in court.
Thank you. And Mr. Rakestraw?
Yes, Your Honor. Your Honor, I'm going to ask for that you follow the pretrial risk assessment of a signature bond. Mr. REUTER does not miss court. He's made his appearances. He has strong ties to the community. He's lived here his entire life. He's currently employed at the chocolate shop where he's worked for roughly 5 years. However, Your Honor, if you feel cash bail is necessary now, as this is now his 3rd case, I would ask for much less cash bail. I would ask for cash bail in the amount of $300 cash. I do believe that is a significant step up from signature bonds. It's apparent from statements that Mr. REUTER might have some mental health issues that needs to be addressed and are probably best addressed while he's out. He will need to reside somewhere else, and it's good that he's getting the help that he needs. But I just don't believe cash bail is necessary at the time. But if you do believe it's necessary, I would ask for cash bail in the amount of $300, Your Honor.
And I do want to see if the state has any response, but before I do that, I had promised to give Mr. Effinger a chance to weigh in. Sir, I'm not trying to put you on the spot. You don't have to say anything. I just want to make sure we're not skipping you. Yep, I think you're unmuted now, Mr. Effinger, if you want to go ahead. Sir, if you're speaking, there's no audio coming through. I do see that you successfully unmuted the microphone. I'm not sure why we're not hearing you.
If you're talking to me, I would.
Nope.
See.
No, Mr. Ryder, I'm trying to hear from Mr. Effinger. And it's not that I want to quiet you or silence you, Mr. Ryder, but it's just for your own best interest, because if you say something, it could get used against you later on, and we don't want to have that happen.
Your Honor, can you hear me now?
That's much better. Thank you.
Sorry about
Yep.
that.
Sir, no problem.
Yeah, I guess at this point I have nothing further to say. I'll just mimic what my wife Susie was speaking with earlier. I've already given statements prior.
Understood, and I appreciate that in that position as well. He's charged with multiple Act 3 offenses. He's on 2 bails, including for an Act 3 eligible offense. He's alleged to have run from the police, and he's alleged to be non-compliant with specific conditions of bond. I see the state's requested bail result as being quite reasonable under the circumstances. I think in the absence of him even being on bond in the other cases, given the seriousness of this and in the alleged running from the police, that would be a reasonable bond. I'll set cash bail at $1,000. I will order that he report to pretrial services by 10 a.m. on the business day following his release from jail. So, for example, if he posts today, he'd have to be there by 10 a.m. tomorrow. But that would apply the next business day from when he posts. They're going to use active alcohol monitoring to make sure he's complying with the no drink condition of bond. There'll also be conditions that he have no contact with Kira H, and that he not be in the 300 block of Southern Grange in the village of Cottage Grove. I did hear what was said by particularly Ms. Effinger about Mr. Ryder's needs. I don't doubt those things are all true. I hope that whatever happens, he's able to get any needed medications, but we're at the point where I clearly have to do something more than a signature bond or some kind of very modest cash bail. Good luck to you, Mr. Ryder. I appreciate both Effinger for being here as well. Mr. Rakestraw, I should have asked you about that. Should we schedule a prelim within the next 10 days?
Yes, please.
Okay, we'll get that on within 10 business days then. Good luck then for everybody.
Next will be Shane YEHLING WEGER. Shane.
All right, we'll call the cases of the state versus Shane YEHLING WEGER. How was your last name really pronounced?
YEHLING WEGER.
YEHLING WEGER. Sorry about that.
Oh.
Yeah, and their cases 25 CM 2741 and 25 CM 2748. Appearances, please.
Hallie Zettel for the state of Wisconsin.
Shane YEHLING WEGER appears by Attorney William Rakestraw. Mr. YEHLING WEGER is not eligible for public defender representation. We are in receipt of the criminal complaints and waive the formal reading in her pleas of not guilty to misdemeanors.
All right, and I did see Deputy Cross give him a sheet that describes how to reapply at the public defender. They're giving that to you because sometimes people want to check in again, or the incomes change, or you just want to double check. Any of that's fine. He's going to help you today. You're in good hands there. You also would have the right to hire a lawyer after today, or represent yourself. If you don't really think you have the money to hire a lawyer, and the public defender still says no, there's also a process for applying over at the clerk of court's office. Sometimes they can hook you up with a lawyer, and there's a payment plan. But again, you're in good hands today. It's perhaps suggested by the circumstances described in the 2 complaints, but Mr. YEHLING WEGER was arrested in connection with the allegations that formed the basis for 2748 and posted a $400 cash bail. So that remains on file in that case. When he posted that, he would have been given a court date for this coming Thursday at 8:30. We're doing that today, so you do not have to be here Thursday morning at 8:30. Yep, we're taking care of both things at the same time. Before I call on the lawyers, I understand there may be a person on Zoom who wanted to be heard regarding bail in this case. I think she's logged in as Holly. If that person would unmute their microphone and then share any thoughts they have, that would be fine.
Yeah, I'm here.
Okay, and you're not required to say anything, but generally when somebody logs into this session, it's with the assumption that they have something they add, and I'm happy to hear from you.
Yeah, we just want him to get help. We want him to get help with drinking, and we want him to get his mental health situated.
I see. Okay, well, I appreciate that information. Anything else before I call on the lawyers?
No, I think that's it.
Okay, thank you very much. Attorney Zettel, state's position on bail in the two cases?
Your Honor, the state is requesting $1,000 cash bail in each case in 25 CM 2741. I'm also requesting no contact with Joey Y and a ban from Joey Y's residence or any place that she temporarily occupies. In 2748, I am requesting conditions that the defendant have no contact with Shannon P or Holly Y. Holly is spelled with a Y. And as well as no possession of any alcohol and pretrial services to monitor alcohol consumption. And a ban from the 2700 block of Dunwoody Drive in Madison. Dunwoody is spelled D-U-N-W-O-O-D-Y. We're at a point now where there are 3 cases, all picked up in a fairly short period of time. It seems clear that this is alcohol fueled, but the defendant is essentially terrorizing his family because of his alcohol addiction. There's concern based on the number and frequency of cases that the defendant will not be able to comply with the court's orders or appear for court. The contact after domestic abuse arrest case certainly implies that those conditions are made quite clear to individuals who are arrested, and that behavior came very soon after the defendant was released. So at this point in time, I do think that $1,000 per case is appropriate. The conditions are self-explanatory.
All right, and I had overlooked the fact that he does have the open case assigned to Judge Kondar. The clerk's going to make sure these cases get assigned to that same judge. Mr. Rakestraw?
Yes, Your Honor. Your Honor, I'm gonna ask to give Mr. YEHLING one more opportunity on a signature bond. It's my understanding, I looked at his criminal, he has no criminal record other than these 3 incidents that have all seemed to have popped up in the last month. It's obvious that he needs to address some of these issues. I'm not sure who he spoke to the first time or if anybody truly made it clear to him, but I made it abundantly clear to him that he is not to go to that house and not to talk to his family while this is being dealt with. He would need to figure out, where he's going to stay. But this is somebody who, like, as I said before, has no criminal record. He's lived in Dane County his entire life. He's had a family. He's been employed as a technician. It's my understanding that he might be needing SSTI. However, Your Honor, with no criminal record and with these being misdemeanors, I would ask for one more opportunity on a signature bond. If you feel signature bond is not appropriate, I would ask for significantly less cash than what the state's asking for.
I should take a quick look at the complaints in these 2 cases. I know I reviewed the Riverside affidavit for the 72-hour violation, but I have not had a chance to look at the complaint. So one moment, please. I guess I'm actually a little confused by the allegations in the 72-hour no contact complaint. It's 25 CM 2741. And it's consistent with a confusion I had when I reviewed the Riverside affidavit, though I did make a finding of probable cause because I thought that the ambiguity could be interpreted in favor of the state based on what was written in that document. It's not 100% clear to me. Is the allegation that it was a violation of the 72-hour no contact because he went to the residence on Dunwoody, or because he arguably attempted to have contact at the hospital, or perhaps both? It's difficult to know which thing is alleged to be the violation here.
Sure, just one moment.
And I ask that question partially because it matters then in terms of the next step of the analysis as to whether there's evidence of an actual violation.
So my understanding is that the defendant first went back to the house at Dunwoody to attempt to have contact with one child who was there. And I say child, they're older teenagers, but and then proceeded on to the hospital to try to determine if the other child was there. When he was told no, he then attempted to check in as a patient himself. So it's both.
All right. And I'm not trying to be hyper technical, but so the going to Dunwoody would be a violation if that's also the residence of the listed victim.
Correct, and that's my understanding. I'm sorry, I'm looking through the reports. I was not the reviewing attorney. But I will come up with an answer here.
Well, and it would have to be based on what's alleged in the complaint, presumably. But then it would beg a different question. If we're talking about an underage teenager, are they subject to the protection under the 72-hour no contact prohibition?
So it does appear based on the complaint, at least my read of it, that is who we're talking about. And that person is 18. So it's
Okay.
his child, but an 18-year-old.
So that would be an adult. I can
Right.
see that. Okay. Well, Mr. Rakeser, I don't know if you want to weigh in on this at all. And again, I'm not necessarily right at this moment trying to resolve the exact issue of what happened, but the kind of the sufficiency of the complaint.
Yeah.
I suppose they're related though, because if I find the complaint sufficient, obviously folks are entitled to make an argument about how serious they perceive the violation to be.
Sure. And Your Honor, I would say that the complaint itself, I do recognize there is some ambiguity about what is or is not happening at that point in time. I kind of was with you. I kind of thought it was enough to get through this, but in terms of just taking into account what's on the face of what's happening, again, I don't know exactly if Mr. YEHLING had a conversation with anybody saying this is what this means, which kind of led to at least a situation where it appears to be in one scenario is checking on one of the children or one of the people who is not who does not have a 72-hour contact order against. I did just explain to Mr. YEHLING that doesn't matter. He can't go to that house. And that's kind of where we are.
Okay. Anything else from the state?
No.
Well, I think there's a lot of room to talk about the alleged 72-hour no contact prohibition, or perhaps the alleged violations, because I think when you read the complaint, there's arguably a violation of it in a couple of different ways. I say arguably because, as I said earlier, I don't know that that's entirely clear. And I recognize the potential for some defenses as a result of that. But it's concerning because most individuals subject to a 72-hour no contact prohibition, particularly when it's their second arrest within about 2 weeks, would probably figure out how to make efforts to completely steer clear of the individuals that are subject to those protections. That would be particularly the case when the defendant is already out on a bond with some conditions involving limitations on contact with at least one of those individuals. The overall fact situation supports some cash bail, and I'm gonna set cash bail. I'll set it at the $400 already posted in case 2748. I will not require the posting of additional cash bail in connection with that arrest or case. I think it's sufficient given the nature of what's alleged there. I'll order as conditions there that he have no contact with Shannon P or Holly Y, that he not consume any alcohol, and that he not be in the 2700 block of Dunwoody Drive. In case 2748, I'll set cash bail there in the amount of $500. And that will have a condition of bond that he have no contact with Joey Y. I'll also order in that case that he not be at any location temporarily or permanently occupied by Joey Y, to include that person's residence or place of employment. I agree with the defense that something more than now going to like $2,000 cash bail total is probably appropriate. They are all misdemeanor charges. The 72-hour no contact violation complaint doesn't allege any specific act or threat of violence. Somewhat more mitigated for that reason as well. Still concerning just for the obvious reasons. I'm disinclined to order pretrial services to monitor alcohol consumption. He's gonna have to post substantial, well, an amount of cash bail. There's not really a request to do location monitoring. I guess I'd rather preserve the pretrial services resource for a case that's a closer call on cash bail versus signature bond, or where it might have a more direct effect on someone's liberty. We'll get a not guilty plea entered on Mr. Yellingweger's behalf for now. The upshot of this, sir, is that to be released, you'd have to post an additional $500. But if you do, you can be released. Obviously, you can't have contact with these folks that you can't have contact with. You can't be at these places. If you violate that, probably going to bring you back here. The state's probably going to ask for an increased amount of cash bail, and we just may not have a whole lot of choice. I don't want to see that happen for all reasons. Good luck to you. Take care.
Next will be JABARI D via Zoom.
All right, let's call the case of the state versus Jabari Lee. It's case 25 CM 2740. Appearances, please.
Kelly Zettel for the state of Wisconsin.
Jabari Lee appears by attorney William Rakestraw. Mr. Lee is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and enter pleas of not guilty to any misdemeanors.
All right, thank you. The booking sheet says that there is a hold. It looks like that's from a probation case that was handled by Judge Genovese. The local court rule says that this case then needs to be assigned to Judge Hilton. So we'll do that. Any position on bail from the state?
State is requesting a signature bond with the condition that the defendant have no contact with Tasha T.
Mr. Rickstrom.
No objection.
I'll order a signature bond with that condition. We'll get a not guilty plea entered for Mr. Lee. Mr. Lee will have some paperwork for you, and then I think you'll be able to be released at least once your agent lifts the hold. Good luck to you. Whoop, I think Mr. Lee wanted to add something. Let's get him unmuted here so we can find out what we need to know.
Oh,
Oh, there you go. Now we can hear you, Mr. Lee. Go. Yep. Go ahead,
Sorry.
Mr. Lee. We can hear
I
you
am
now.
not going to let Tasha Nicole Teasing lie to you guys. I'm a Black African American male, and unfortunately, I'm not pulling the race card, but in this system, it seems like we get confined. There's a 90% conviction rate within Wisconsin, wait, sorry, I'm talking to them. There's a 90% conviction rate within Wisconsin system, and this is very unfair, especially for Black males on papers. It's very easy for females, not to say Caucasian females, to get males like myself of my ethnicity arrested for bull crap. Excuse the French, but I have a lot of documentation of my own stating exactly what happened during these events. Now, Tasha is very mental.
Are you in disagreement with the signature bond?
Okay, I just want to finish off. She struggles from a lot of mental health issues.
Mr. Lee, this is attorney, Mr. Lee, this is Attorney Rakestraw. I'm representing you right now. I would advise you to stop talking. Just trying to help you out here.
Okay.
You have a signature bond. You're being held on just the revocation hold. That's it.
But she's defaming my character, sir. I cannot let that happen.
I understand that, but this is not the venue for you to do that. I'm trying to help you out here.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
That's super good advice. It really just doesn't get better than a signature bond with a no contact order on a charge of this sort when somebody's on paper. So you should go with that, and you'll certainly have opportunities to be heard regarding this if it proceeds to trial. Good luck to you.
Thank you.
You're welcome. Bye-bye.
Bye. That's what we have a chance to like represent myself, or like represent any of the information I had.
Young. All right, we'll call the cases of the state versus, do you pronounce your first name Trentawayne? Trentawan. Thank you. Young. Cases 25 CF 2609 and 25 FO 1785. Appearances, please.
Callie Zettel for the state of Wisconsin.
Trentawan Young appears by Attorney William Rakestraw. Mr. Young is eligible for public defender representation. We are in receipt of the criminal complaint. Waive the formal reading. Enter pleas of not guilty to misdemeanors.
All right, thank you. The booking sheet says that he's being held on a hold. I'm just looking to see if there's a specific branch to assign the case to. 1 second. It looks like he was placed on supervision by Judge Mitchell in branch 4. That judge is not in the criminal rotation. So I think we're just gonna have to let the computer randomly pick a criminal branch judge to be assigned to the case. A couple of other things going on here. So we do have the initial appearance in the felony case. We're separately doing an initial appearance in the civil forfeiture case. That's 25 FO 1785. There is actually a $300 bond already posted in that forfeiture matter. Maybe the state has a position regarding bail on at least the charged criminal case.
Yes, Your Honor, the state is requesting $5,000 cash bond in this case with the condition that the defendant not use or possess any dangerous weapons. Well, let me first say, the defendant was convicted in July of 2024 of being an adjudicated delinquent in possession of a firearm. That is, I believe, the case possibly that Your Honor was referring to. He is currently on probation for that offense, and he has been absconding from probation since September of this year. Additionally, I do have information from juvenile court records that I believe is relevant to the conditions of bail here. So I would request permission from the court to disclose that at this time under Wisconsin statute 938.396 sub 2G sub D.
And Attorney Rakestraw, any position on that request?
As I do not have access, I would object. And I have not seen any of this information previously.
Well, I don't know that that's an unusual situation at an initial appearance or a bail hearing. I generally would find it helpful if we had information about a history of, for example, non-appearance or not being substantially not being compliant with supervision requirements. I'll grant authorization to make arguments based on information of that sort. I'll ask the state to refrain from sharing any more sensitive information like maybe treatment information or counseling information or at this point, information about prior placements. I can see where those things are much more sensitive in nature than basic compliance with conditions and the like.
Just for clarity, what I would like to share is just the fact of a conviction, or an adjudication rather.
Well, I mean,
Not
you're welcome to share that,
specific.
though it's already really in the public record because there's the complaint alleges that he's has a prior adult felony conviction for possession of firearm after being adjudicated delinquent for a felony. So I'm kind of aware of that just
Okay.
based on what's in the complaint.
I'm sorry, I'm going off the bail notes. I was not the drafter of the complaint. So that is the other thing that I wish to share with the court is that in addition to the adult conviction, there was a adjudication in March of 2023. So in the course of about 2.5 years, we have 3 separate cases for the same, almost exactly the same behavior. Certainly the defendant had noticed that he is not permitted to have firearms anymore. This is also, I'll note, the 3rd probation hold for illegal possession of a firearm, a weapon, or ammunition of some kind while the defendant's been on probation. Additionally, the defendant in this case, fled from law enforcement on foot and attempted to hide the firearm under some leaves. Obviously knowing that he had up to that point been absconding. So significant cash bail is appropriate, though it is at this point somewhat academic. There is a DOC hold in place.
All right, Mr. Rakestraw.
Yes, Your Honor. For this one, I understand the seriousness of these allegations and Mr. Young's alleged history. I think $5,000 is excessive. In this matter, I would ask for cash bail in the amount of $1,000. As somebody Mr. Young's age, I believe $1,000 is still a significant amount of money. He does have strong ties to the community. He's lived here his entire life. He was working at fast food for years. His entire family lives here, but I do understand the seriousness. So I would just make a recommendation of cash bail in the amount of $1,000. He's going to be in custody anyway.
I appreciate the realism of recognizing that this is a cash bail situation, and it is. I also don't entirely ignore the allegations in the forfeiture matter, which are, according to the Riverside affidavit, that he's alleged to have fled from police after a call to potential gunshots. That's not irrelevant to the analysis here as well. On the charged criminal case, I'll set cash bail at $2,500. I'll order that he not be armed with dangerous weapons. In the forfeiture case, I'll get a not guilty plea entered on his behalf for now. He can be released without bail in connection with that. He's still going to have to deal with the probation hold also, of course, as has been noted by everybody. Should we put on a preliminary hearing on a timely basis?
Yes, please.
Okay, we'll get that put on right away. Mr. Young, take care. Good luck to you.
Yeah, appreciate it.
Yeah, you're welcome.
Next to be Menace Waitman via Zoom.
All right, we'll call the case of the State versus Menace Waitman, case 25 CM 2743. Appearances, please.
Callie Settle for the state of Wisconsin.
Menace Waitman appears by attorney William Rakestraw. My paperwork does not say whether Mr. Waitman is eligible or not, although he is currently represented by someone from our office in his other cases. So he'll have to reach out to our office to get reevaluated. We are in receipt of the criminal complaint, waive the formal reading, enter plea of not guilty.
Okay, that sounds good. Mr. Waitman is in custody on cash bail in connection with either 1 or 2 other open felony cases. I think he's also on a supervision hold. the open cases are assigned to Judge Hyland, so this one must be as well. This complaint alleges behavior that actually, if I understand it correctly, precedes when he was most recently taken into custody and in charge with the most recent of the cases. What's the state's position regarding bail on this?
Your Honor, if I can just have one moment.
Sure.
I'd like to take a look at the dates. I didn't realize that.
It actually would be timing that precedes both of the pending cases, though not the ones that he's on supervision for.
Is it? I'm seeing. So I have incident date on this case, 10/19/25. And then I see in, let's see, 25 CF, 2564 incident dates on 10/17, 10/19, and then one on 10/28.
That could be. I don't
Okay.
think he was taken into custody until October 28th.
Okay.
And it appears that we're doing this quite piecemeal. I think in 2373, he had his initial appearance on October 30th. And then he had the initial appearance in 2564 on November 10th, though he's been in continuous custody since October 28th.
I see. Okay. I just wanted to get a clear idea of the dates. I know that sometimes these types of referrals do come in piecemeal in that way. So the state is requesting $500 cash bail in this case with the condition that the defendant have no contact with Alexander W. and that he be banned from the 6600 block of Century Avenue. I'll note for the court in June of this year, as the court alluded to, the defendant was convicted of several cases, 20 charges across 7 cases. He received a sentence with imposed in state prison on at least some counts. The defendant has an extensive criminal history across several states, our state, Texas, Illinois, and Arkansas included. He is currently on supervision in all of the Wisconsin cases in which he received convictions. He'd been in custody for the pendency of the case based on the repeated, or I should say the frequency with which he was picking up cases and the repeated behavior. In the most recent 3 cases, the defendant was ordered $1,500 cash bail in each case. I recognize that this is a sole count misdemeanor, however.
Yeah, Mr. Rakestraw?
Yes, Your Honor. Taking into account his potential revocation and the 2 open felony cases where he has significant cash bail, or at least significant to somebody who's eligible for public defender representation, which appears he might be based off of who is representing him currently. I believe a signature bond would be appropriate here, just in light of the fact that he does have potential revocation where there's imposed in state prison, as well as 2 felonies where he's got $3,500 in cash bail. I believe any more cash on a solo misdemeanor, which when it happened in light of the other felonies is a little questionable, or a little up in the air, but I just feel that any more cash is excessive. And taking into account the entire picture, I believe $3,500 cash bail is appropriate for an overall amount of bail from Mr. Waitman.
It's probably debatable whether if we had done an initial appearance in all 3 cases at the same time, whether that number would have been 3,000, 3,500, 4,000. I mean, there's some subjectivity to all this, and I recognize that. I always endeavor to not put somebody in a position where their bail becomes higher in the aggregate because we're doing the initial appearances separately. I also have to consider the practical effect of this. If I order a signature bond in this case, there's at least some chance it's going to wreak havoc with potential credit issues for him at some point. It's really not a signature bond case on the merits of it either. I think the state's requested number is measured. It's commensurate with the fact that he's charged with the a lower end misdemeanor charge here. Though as a repeater, and it's kind of hard to argue, both legally and factually that somebody is a repeater when they're literally, on probation out of 7 separate cases, and now they're on their 3rd pending, case. Hopefully this is it. This is the total amount of bail that winds up getting set across this, and everybody's moving forward. But I don't think I can do much better than what the state proposes here. I'll set cash bail at $500. I'll order the conditions about not having contact with Alexander W. or being in the 6600 block of Century Avenue. Hope things start to get better from here. Good luck to you.
Next will be Timothy Armour.
All right, we'll call the case of the state versus Timothy Armour, case 25 CM 2739. Appearances, please.
Kelly Settle for the state of Wisconsin.
Timothy Armour appears by attorney William Rakestraw. I do not have verification about whether Mr. Armour is eligible or not eligible for public defender representation. So he'll need to reach out to our office if he wants us to represent him. We are in receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty to the misdemeanors.
Okay, thank you. As the complaint implies, he does have some open cases. It looks like there are 6 open misdemeanor cases assigned to Judge Peacock, as well as 2 felony cases assigned to the same judge. So we have to get this case assigned to her as well. Does the state have a position regarding bail in this matter? Oh, and I should just note, I think for everybody's benefit, that I believe he's being held on cash bail in connection with some of those other matters. This must be another case where we're doing things separately for some reason. Attorney Zettel, any position on bail?
State is requesting $1,000 cash bail with the condition that the defendant have no contact. I'm going to spell this first name NAKANWAGI, last initial N. Additionally, the state's requesting that the defendant not be permitted to operate a motor vehicle without a valid driver's license. And I do believe both of those conditions track with some of the other open cases. As the court noted, the defendant currently has 8 open cases. He here was being served with a warrant because he was in warrant status for a felon in possession case, which is one of the open cases. When law enforcement went to serve that warrant, they found him disregarding multiple bail conditions. There isn't necessarily new criminal conduct in the sense of an overt act, but it's a complete and utter disregard for the conditions that the court has set, the conditions that the defendant promised to abide by when he signed his bond forms. So based on that alone, a substantial amount of cash is appropriate.
Attorney Rakestraw.
Your Honor, I understand the need for cash in this matter. He's already being held on $3,000 cash bail. I believe that is a significant amount of money. However, I understand because of the bail jumpings and why some extra cash might be necessary. However, taking into account the totality of it, I do not believe it needs to be an excessive amount more. Seeing as how Mr. Armour still has not posted the $3,000 cash that is on the books for him. So I will request cash bail in the amount of $500 on the new case. And then that way it will set a total of $3,500 and he can go to Judge Peacock and see if that can be adjusted later. Seeing as though there's no new overt criminal activity, this is violations of bail conditions.
Understood. Oh, it's a close call as to whether the complaint actually has probable cause for count 4. It alleges a bail jumping for driving without a valid driver's license in violation of a similar condition in a separate case. It does refer to him as having been identified by an ID card and locating Wisconsin identification card in the vehicle. I'm mindful of the fact that one can't have both a Wisconsin driver's license and a Wisconsin ID card. So that implies the absence of a valid driver's privileges, at least for probable cause, I suppose that's the case. Like I said, that's kind of a close call, but it relies on inference, but I think the inferences are there. What doesn't really rely on inference is the fact that the complaint alleges that he signed bonds in 3 separate cases promising not to have contact with this person. And it says that he's in the car with her. Cash bail set at $1,000. I'll order that he not have any contact with her. I'm going to simply order at this point that he not operate a motor vehicle. That's a cleaner condition and is appropriate if he now has 2 separate cases that allege essentially a violation of that. Mr. Armour, we're gonna get some paperwork put together. We'll get you another court date. You do, as noted by Mr. Rakestraw, have the right to ask Judge Peacock to review bails on any of this stuff. That's totally within your rights. I just can't order a signature bond or low cash bail given the number of pending cases at this point. I think the state maybe did you a solid even by not charging with some felony bail jumping charges here that could also have applied. Good luck to you. Take care, Mr. Armour. You're welcome.
Stay with whoever that is.
I'm ready. Next would be Stuart Westcott.
We'll call the case of the state versus Stuart Westcott. It's case 25 CF 2608. Appearances, please.
Hallie Settle for the state of Wisconsin.
Stuart Westcott appears by attorney William Rakestraw. Again, I do not have verification about whether Mr. Westcott is eligible or not for public defender representation. He is, however, represented by our office on his open criminal matter. We already received the criminal complaint, waived the formal reading, and that's it.
All right, thank you. And I did see that Deputy Gilmore gave Mr. Westcott a copy of the information sheet about how to apply for a public defender. He does have an open felony case assigned to Judge Peacock. We'll get this case assigned to the same judge. What's the state's position regarding bail?
State is requesting $500 cash bail with conditions that the defendant not use or possess any controlled substance or drug paraphernalia without a prescription, and that he be banned from the UW campus. The defendant does currently have an open case with conditions to not be on the UW campus. He received a signature bond and then was back on campus with granted a very small amount of drug paraphernalia rather. At this point, the flagrant violation of bail conditions, some amount of cash is appropriate. I will also note that there were bench warrants issued for Mr. Westcott in May of 2023, July of 2023, December of 2023, and June of 2024.
All right, thank you. And if you need a moment or two, Mr. Rakestraw, it's totally fine.
Yeah, 1 second.
Sure.
Trying to get a signature.
Yes, Your Honor. In this matter, I'm going to ask for a signature bond. Mr. Westcott is indigent and homeless. I believe that's part of why he's kind of where he is. He's staying where he's able to stay. This is, I understand he was not supposed to be on UW's campus, but it doesn't appear as if he was creating too much of an issue there at this time. I understand he had the methamphetamine on him, or allegedly was possessing methamphetamine. However, I don't think that is a major issue, even though I understand he has the open case. Due to Mr. Westcott's finances, any charge that he has is going to be him sitting in custody. So that's why I'm asking for a signature bond, Your Honor. If you feel cash is appropriate, I would ask for less cash than what the state's asking for.
And I did notice that the most recent notice of hearing in the pending case got returned by the post office. It was sent to the same address on East Wash. Is that the best mailing address you have at this point, Mr.
Yeah. What's the weekend?
Yeah.
Yeah. And I bring it up because of course I don't want to see you miss court here in a couple of weeks when you
Yeah, I
have
won't.
another court date. You'll want to keep in touch with Mr. Frederickson or be checking CCAP or doing
Yeah.
something to keep up with it.
Yeah.
Okay. Do you have a phone that gets text messages?
No, I do not.
Okay, otherwise I'd suggest that, but that's not an option. Anything else from the state?
No.
the state's position isn't out of line. I also think a signature bond could be appropriate here. He's charged with a possessory drug offense. I know he's also charged with being at the UW campus where he wasn't supposed to be. It did take about 3 months for him to get picked up on these new charges, and I'm fairly mindful of the fact that the UW police generally know who's banned from campus and keep an eye on that. It leads me to believe that Mr. Wescott wasn't regularly violating those conditions, because I think he probably would have been back here sooner than that, had that been the case. Again, it's a close call. I'll go with the signature bond, though. I'll order as a condition that he not be at the UW ban area as depicted on the map that Deputy Gilmore's giving him a copy of. We'll keep one for the court file too. I'm going to decline to order the drug condition because that's just against the law anyway. It doesn't, in my view, need a separate bail condition. We'll get I was going to say we'll get a not guilty plea entered, but actually the two charges are both felonies. What about the time limits for preliminary hearing on those?
When is his next court date on the open case?
Yeah, it would be December 4th. I can't put it on at the same time, however.
No, I understand. Is that set for a preliminary hearing or?
No, it's past that.
Okay.
It's like a pretrial conference in the branch.
Yeah.
We can waive time limits, Your
Okay.
Honor.
All right, I'll accept the waiver of time limits. I think you're gonna be able to get out today, Mr. Wescott.
Thank you very much.
You're welcome. The way you can repay that is by showing up at your court date
Yeah.
and not getting picked up on something.
Thank you very much.
Yep, I hope it works out for you. Take care.
Next, Steve, Goodwin, yes, sir.
All right, we'll call the case of the state versus RAHEEM Goodwin. It's case 25 CF 2613. Appearances, please.
Hallie Zettel for the state of Wisconsin.
Raheem Goodwin appears by attorney William Rakestraw. Mr. Goodwin is eligible for public defender representation. We are receiving of the criminal complaint, waiting for formal reading. Enter pleas of not guilty to any misdemeanor.
All right, thank you. Mr. Goodwin does have 4 open felony cases assigned to Judge Burrs. He is being held on bench warrants in connection with those cases. Because their cases assigned to branch 11, the bench warrant return hearings will get held in the branch. That judge prefers to handle her own bench warrant returns rather than having them dealt with by the commissioner. But I do need to address bail in this new case. Attorney Zettel, any position on that?
State is requesting $1,000 cash bond in this case with conditions that the defendant be banned from state and Langdon ban area. I'll note for the court that the defendant is now on his 5th open felony case here in Dane County. This puts him at a much greater chance of a lengthy jail sentence or prison term when he eventually resolves those cases. Here in this case, he's violating specific conditions of bail by having drug paraphernalia, controlled substances on his person. He's also been in warrant status across the 4 previous cases. Since September 24th of this year, he failed to appear for court and never reappeared. When he was confronted by law enforcement here, he allegedly resisted and repeatedly kicked police officer Batusich. He has been given signature bonds and lower amounts of cash bail by the court, and it has not been sufficient to ensure either appearance or compliance with the law. So $1,000 seems the minimum amount appropriate.
So I'm seeing that he posted $250 and $500 in 2 of the other cases, and then 2 of them have signature bonds. Does that square with your math?
That does appear to be correct. Yes, it does look like some of those amounts were lowered over the course of time. earlier in the summer of this year. Some of those amounts came down a bit. So I do believe those are what he has already posted. Of course, I'm asking for $1,000 just in this case. Judge Burrs will address the other cases in their own time.
Understood. Yeah. Mr. Rakestraw, the defense position?
Yes, Your Honor, I would request cash bail in the amount of $750. It shows respect for the escalation of the past cash bail. It's also stated in light of what I imagine will be significant cash bail that Judge Burrs will be handing down when he goes and deals with the warrants there. So I'm just trying to take into a collective amount of money that I expect to be there, and I do. So I recognize why $750 is appropriate because of the past posting of bail. But I don't think much higher than that is appropriate based off of what I expect Judge Burrs to do.
Any response from the state?
No.
Okay. Well, they're both fairly reasonable recommendations. In that situation, I'll go with the lesser of the two. I'll set cash bail at $750. We'll get a not guilty plea entered on his behalf to any misdemeanors. I think there are a couple. And should we put on a prelim within the next 10 days?
Yes, please.
Oh, I'm sorry. And I did intend to adopt the conditions of requested by the state. So
I think that was just a ban, the state plan, like that area.
yep, that's fine. And we'll make sure that he gets a copy before of that ban area map before he's released too. Take care, Mr. Goodwin. Bye-bye.
Next will be Amari Dixon.
Did you order 750 or 1,000?
The 750.
Okay,
I should have been clearer about that.
I was reading.
Yes, I want one.
I don't think I said it all that clearly. I think I sort of indirectly referred to it. Why don't we call the cases of the state versus Amari Dixon? Their cases 24 CM 2626 and 25 CF 2606. Appearances, please.
Callie Settle for the state of Wisconsin.
Amari Dixon appears by attorney William Rakestraw. Ms. Dixon is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and are pleased of not guilty to any misdemeanors.
Thank you. In the case from last year, we're here on return of a bench warrant issued by Judge Highland. It looks like that was issued on November 5th. That also means we have to get the new case assigned to Judge Highland and address bail in both. Attorney Zettel, any position on that?
Yes, Your Honor, state is requesting $150 in each case. In 24 CM 2626, I'd ask for the conditions to remain as previously ordered. In 25 CF 2606, the state is requesting condition of no use or possession of any controlled substance or drug paraphernalia without prescription. And I'll note for the court, these are the only two open cases for Ms. Dixon that I am aware of at this point in time. The circumstances of both cases are incredibly similar. They're almost identical in that Ms. Dixon is part of a traffic stop and the car ends up being searched in both cases, and small amounts of drugs and drug paraphernalia are found. It's absolutely concerning that the defendant failed to appear. However, it was a fairly recent failure to appear. It's also concerning that she's violating bail conditions, but it's possessory drugs. The behavior that led to the stop and the search, I don't think was really her own. Cannot possess drugs, especially on bail conditions. I hope that a short period of time in the jail has made that clear to Ms. Dixon, but I don't know that setting high amounts of cash is going to do anything to deter that behavior in the future.
And Mr. Rakestraw.
Yes, Your Honor, I haven't spoken to Ms. Dixon. She got her dates confused in terms of why she missed court on 24 CM 2626. She thought she was supposed to be in court on November 15th, and it turned out she was supposed to be on November 5th. She stated she was in the process of reaching out to her attorney, and that is what got picked up. Before that, as the state stated, wasn't necessarily through her actions that she got picked up, but obviously she's still kind of around things that she's not supposed to be around. However, Your Honor, with these being her only two cases and they being possessive drug charges, I'm going to ask for a signature bond. Hopefully these few days that she's been in custody, been a wake up call to let her know she has to show up to court and try to move forward with these situations. So I'm going to ask for a signature bond on this, Your Honor.
All right, I'm gonna grant the defense request for a signature bond, partially for the reasons identified by Mr. Rakestraw about the efforts to take care of the missed court appearance and the circumstances leading to it, and partially because I'm simply not gonna set $150 cash bail on a felony case. We'll get a not guilty plea entered on her behalf to the misdemeanor charges. And I'm gonna also decline to order the drug-related condition because if the two complaints prove nothing else, it proves that that's a crime anyway, and for that reason, it's not necessary to make it a separate condition of bond. Does she want a prelim within the next 20 days?
Commissioner, that's just in the new case. Are you continuing the prior bail conditions in the old case? The only condition was not possessed drugs or
Well, that was a condition in the other case, wasn't it? Well, I guess I'm not gonna remove it, but I'm not looking to add it in the new case either.
We can wait time, please.
Okay, real good. We'll accept the time limit waiver. Ms. Dixon, I think this means you're gonna be getting out of here today. You're gonna have two different court dates coming up, one in the new case and one in the old case, so it's gonna be double the stuff to pay attention to in the May. I want you to be able to do that so you can get there and not have to go through this process. All right, good luck to you. Take care of it. You're welcome.
That's everyone,